Yes, please.
May I pay for listing of a writ petition, my lord, regarding retirement benefits have not been given, my lord.
Next.
On 11th, my lord. Okay.
May I please, your lordship? With consent of the other side, your lordship, I beg to mention item number 6 and 7. In these two cases, we are filing our affidavit, your lordship. So matter may be taken up on 18th, your lordship, if it is not inconvenient to this.
6 and 7, you are
Six.
appearing for whom?
Our private respondent 9, 10 and 11.
I for the petitioner also.
No objection.
No,
We'll adjourn it
Let's
for
say-
2 weeks.
it may be fixed, Lordship.
After 2 weeks. Mr. S. Bothakul and counsel for the respondent numbers 10, 11, 14 and 16. Appearing in these writ petitions. Appearing in item 6 and respondent number 9, 11, 15 and 16 in item 7 have prayed for 2 weeks time
Lord.
to obtain instruction and file.
No, your lordship, we will file, your lordship, by this time. We have received instruction.
To file counter affidavit.
Lords.
Since the prayer is not opposed by the petitioner's counsel, same stands allowed. Let this matter be listed for admission hearing again after 2 weeks as a fixed item.
Lords.
Lordship, date may be fixed, it will be.
It is fixed item after 2 weeks. You
File
calculate the date
Apply.
and tell your senior.
Fine.
My lord, this matter may be listed on 8th, my lord. Matter relates to family pension, my lord. And it's pending for the last more than 1 year, my lord.
3rd week of November. 3rd week of.
Yes.
May it please, your lordship. Lordship, with the consent of other side, I beg to know item number 15, lordship.
Hmm.
In this case, lordship, we have to produce the lordship, GARC's record, lordship. General Assam Rifles Code records we have to produce. So lordship may give 3 weeks time, we will produce it, lordship.
How much time?
3 weeks time, lordship.
Mr. K. Gogoi, learned CGC appearing for the respondents submits that the report
Of GARC, lordship.
of GARC,
Records of GARC, lordship.
the records of the GARC are not available with him and therefore 3 weeks time
Lordship.
to call for the records. The prayer is not opposed by Mr. A. Tiwari, learned counsel for the petitioner. In view of the above, let this matter be listed again after 3 weeks.
No.
May I please, Lordship, I beg to mention for listing a matter, Lordship, matter relates to regular pension, Lordship. Any day.
3rd week of November.
May it please your lordship, I beg to mention for listing of a matter, lordship.
3rd week of November.
May I please, your lordship? I beg to mention for listing an IA on 7/11, your lordship.
Why? What is the IA?
Lordship, for deletion of area of parties, your lordship.
For?
For deletion of name from the area party, your lordship.
So it will come and it's, what is the urgency in this matter?
Lordship, main matter is listed on.
Rejected. Yes, next.
I beg to mention for listing. The matter was last listed on 28th of
4th week of November.
May please your lordship. Lordship, I beg to mention a listing of a matter, your lordship. What happened in this matter, lordship, I have been show cause and simultaneously criminal proceeding is also going on same set of charges, on same witnesses. And my anxiety is that if my next date of appearance in the departmental proceeding is on 8th, and if I have to disclose my everything, lordship, the criminal case will be compromised.
14th of November, other matters are fixed. You give the date.
Lordship,
14th of
I was praying for tomorrow, your lordship.
No, no.
Maybe on Friday, your lordship.
Is it a motion matter?
Yes, lordship,
It's a
motion.
motion.
Motion matter, lordship.
Then Friday.
Much obliged, lordship.
May I please your lordship, I beg to mention for listing of a matter, Lordship. The matter pertains to non-payment of arrears salary for the.
4th week of November. You write 4th week of November.
May I please the Lordship, I beg to mention for listing of a matter that was last posted on 1/5/20.
4th week of November.
May I please your lordship, I beg to mention for listing of a case.
4th week of November.
Lordship.
Yesterday, there was a mention of IA that was supposed to be fixed today as per the honorable court. But today, a matter is not yet come in the cause list or all in the supplement. So
Mention
tomorrow,
of IA in which court?
yesterday in this court, sir. It was already passed that today was supposed to be the date fixed, but tomorrow it has been fixed in the cause list. However, there is an urgency, my lord, because today is the date fixed for the departmental inquiry.
So what will happen today?
So
Inquiry will be closed and penalty.
No, Your Honor, there is a stay already there.
Hmm.
IA was filed because the order was not reflecting regarding the stay was extended. On this behalf, IA was supposed to be filed. That is the reason we filed the IA before this.
It will come tomorrow. You mentioned before the DP that the IA
My
has
lord,
been filed. Yes.
Daily list for motion item 1.
Lordship. Here we select the impugned order, which was passed in contravention of the order passed by the Honorable High Court, Your Lordship.
Lordship, on last occasion, we were supposed to take instruction, Lordship. I have received verbal instruction, the order impugned which I have challenged, that will be revoked, Your Lordship, by today or tomorrow, Your Lordship. We have been given assurance of that. I'll produce the order here tomorrow. By tomorrow, Your Lordship.
Fixed matter.
Heard Mr. L. Mohan, learned counsel for the petitioner, also heard Mr. R. R. Gogoi, learned standing counsel, Forest Department, Assam, who submits some verbal instruction that the order impugned in this read petition is in the process of being revoked, and therefore he seeks 3 days further time to produce a copy of
Okay.
revocation of the impugned order. On the request of Mr. Gogoi, let these matters be listed again on 12th of November 2024 as a fixed item, as fixed items.
Obliged, Lordship.
So as to enable him to produce the copy of the
Of the
order.
Obliged.
For admission item 3, 4 at a time.
Yes. You are appearing in which case?
Lordship, item number 3, 4 and 5, Lordship.
Who is appearing in item 3?
In 3, we are. There was a subsequent advertisement issued, because my lord was pleased to issue notice. Yes, if 4 and 5 are taken care of, this will automatically get. 4 and 5 pleadings are otherwise complete, and perhaps it is also part.
Let us see 4 and 5. So the affidavit in terms of order dated 23/7/2024 has been filed.
Yes, filed, Lordship. It was filed on 18/10/2024.
আৰু আমি যেটা 19 যেটা 57 লিষ্টখন দিছিলো সেইখিনি আমাৰ 54 ভ্যাকেন্সি আছিল তো বাকি তিনটা
Mr. Nayak, what is this page 170? Minus 27 vacancies were what?
minus 27 those who were appointed as per the selection lordship. Same selection. In the selection, a select list of 57 persons were declared lordship. Out of those 57, 27 plus 5 were appointed, engaged already, given upon promotion.
So these vacancies have arisen after 2017.
No, lordship may kindly see vacancy 32. That was the vacancy on the date of issuance of the advertisement. Result was declared on 7/11/2019 lordship. Till that time lordship, another 10 plus 12, 22 vacancies arose lordship. But in this case, this is a case lordship. This is such an examination where vacancy does not matter at all. If the person is qualified, his name is declared, he are qualified. Whenever vacancies will arise within that period of 1 year, he will be given promotion. In this case, lordship, a select list of 57 persons were declared, but up to the date of publication of result, lordship, only 54 vacancies were there. So even if 57 persons were declared selected, out of those 57, only 54 could have been given promotion.
No, but you just now said that vacancies don't matter.
Yes, lordship.
Then,
Because lordship,
no, Mr. Nayak, perhaps you are contradicting yourself a bit. In one hand, you said that vacancies don't matter. Anybody who fulfills the criteria can be included in the list. And then you are saying that there were 57 vacancies.
no, not 54 vacancies,
54 vacancies,
but select list was of 57.
57. So how does it matter if vacancies are not relevant?
So it doesn't mean that even if you are selected, you will get promotion. So that is what I'm trying to say, lordship. At the point of issuance of the advertisement, 32 vacancies were there. Subsequently, it increased. Some persons got retired. And on the date of issuance of the result, the total vacancy was 54. Select list contains 57 names.
All right, who's appearing in this case? Mr. Chaudhary? K.
Yes,
Chaudhary?
Lordship. He is up next in court number 1, Lordship.
So you will argue?
No, Lordship. Lordship may kindly pass over the matter for the time being. He will be here. Lordship.
If your lordship permits me, may I clarify, if your lordship has a look at the rules, the whole position would be clear.
No, but don't want to go in a peaceful manner.
That is,
I'm not keeping it part heard. So either do it on another day then. If he's not available.
I'm at your lordship's disposal.
আমার part to go with.
I'm not keeping it part heard.
Otherwise, matter is a very small matter, lordship.
I know. That's
Only
why
lordship will go through the rules, everything will be clear, lordship.
you argue if you want to argue or you seek adjournment. Do one of the two things.
If Lordship may kindly accommodate both the.
We'll see if time permits.
এই কেছটো সোনকালে যদি কৰি নিদিয়ে নহয় এইকেইটা এফেক্টেড হ'ব কাৰণ মোক কৈছে যে লিষ্টখন এক্সটেণ্ড নকৰে
Yes.
My lord, Lordship was right. I was wrong. Lordship was right the other day.
Why? What
In
happened?
this case. Because one part, that suspension period shall be treated on duty. That part, for preparing the case, that part, instead of looking that part, I went little further. But Lordship alerted me the other day, my lord, that no, there is a rules for that. For treating the suspension period as on duty, there are rules for that. Yes. Rule 61 of the pension rules, read with rule 54B of the FRNSR, my lord. And lordship, there is a judgment also, my lord, on this issue. How to be treated this period as on duty, my lord. Now, lordship,
See
may
what is
kindly,
this case?
yes, page number 41, kindly come to the.
Let me understand what the case is.
Yes, please come to page number 41.
Yeah,
my lord.
just a minute. So the petitioner is still in service.
Yes, he has been reinstated, he is working.
He's
In
working.
terms of lordship's order, he has been reinstated, my lord.
He's working as what?
He was a medical and health officer.
Now he's working as what?
Same post he's working. Now
Medical
this
and health officer in which place?
medical and health officer, my lord, that was appointed in 14/12/04 and he was suspended on 2506. 2506, page number 32. And this honorable courts passed order 13/3/20.
No, my question was he's posted in which place?
He's in Mangalday,
Sorry?
in Mangalday.
So what is the relief rate for in this petition?
Pardon, my lord.
Yes, relief paid. for.
Relief, my lord. Kindly see page number 42 in the imperial order. When your lordship is
No, come to page 17. Relief paid for is in page 17, not 40.
page 17, my prayer. That's my prayer, yes. My lord, during the respondent to pay sub allowance 70%, we have got it in terms of the order passed by your lordships, my lord, this honorable court. Setting and quashing the imperial order, so far it concerns with the treating the suspension period of the petitioner for pension purpose only. Not to be treated, they have written, my lord. So next is directing the respondent authorities to treat the suspension period of the petitioner to be as on duty, my lord. Then grant increment salary. Then 5 is, my lord, promotion to the next higher post. Because all my colleagues, they have been promoted, my lord. So now the problem is, now since they have put me in the same position, my lord, and kindly see, when they place me in suspension pending department proceeding, they have done nothing. They kept hanging like that, my lord, hanging like this. It is only when I approach your lordships, my lord, there's a direction to consider, look into it, whether there was a criminal proceeding or department proceeding. So there was nothing, my lord. Now they have reinstated me, but with the idea that this period shall not be treated for the purpose of pension, my lord. Now this is what is creating the problem. So what 75% is concerned, we have got it, my lord. The first thing is now this period of suspension of teacher on duty, my lord.
Yes,
There's a that lordship is
please argue your case. What is, yes.
yes. Now first thing is, my lord,
Hmm.
as per rule 54, my lord, kindly my lord, 54B. Lordship, my lord, instead of going to the books, this is quoted in the judgment, my lord. This will be easier, my lord. At the same time, lordship can see Buddha, my lord. Yes, yes. This is quoted here in this. Yes. This is by Just Ujjwal Bhaiya, my lord. In his referred 3 or 4 cases in. Now please come to paragraph 17, my lord. Paragraph 17, the relevant part. This is similar to my case. Fact in this case are not in dispute. Petitioner was suspended following his arrest in a criminal case. The case was finally ended in acquittal of the petitioner, whereafter he was reinstated in service. The suspension period of the petitioner was from 9/01 to 07. Though in the order of suspension, it was stated that disciplinary proceeding was contemplated, So no such proceeding was initiated against the petitioner. Therefore, the decision recorded in the impugned order dated 11/10/07, the disciplinary proceedings contributed against the petitioner stood closed, does not reflect the correct position as in the absence of initiation of any department proceeding. Closure of the same does not arise. As a matter of fact, what it conveys is that state had decided not to have any department proceeding against the petitioner. In my case, they place suspension saying pending royal department proceeding. Nothing has been done. Next, my lord. The question therefore arises as to how the period of suspension is to be treated. The FR 54B, that's what in the book. When FR 54B1, when a government servant who has been suspended is reinstated or would have been so reinstated, but for his retirement or superannuation while under suspension, the authority competent to order reinstatement shall consider and make a specific order. Here, the first sentence, when a government servant who has been suspended reinstated, here, the authority competent to order reinstatement shall consider and make specific order. See the next A. Regarding the pay and allowances to be paid to the government servant for the period of suspension, ending with reinstatement or the date of his retirement, superannuation, as the case may be. Mine one is first part. Whether or not said period shall be treated spent on duty on this issue. Next, 3. When the authority competent to order reinstatement is of the opinion that suspension was wholly unjustified, the government servant shall, subject to the provisions of 8, be paid full pay salary which would have been entitled had he not been suspended, like me. Provided that where such authority is of the opinion that termination of the proceedings instituted against the government servant had been delayed due to the reasons directly attributed to the government servant, it may, after the hearing the representation, if any, submitted by him, direct for reasons to be recorded in writing that the government servant shall be paid for the period for such delay only. Here in this case, my lord, this cannot be attributed to me. It is they have faulted, my lord. Next, in a case falling under sub-rule 3, the period of suspension will be treated as on duty, my lord. Now, kindly see the operative part. As already noticed, there was no consideration by the competent authority and consequently no specific order was passed on the above subject of the matter. As noticed above, the competent authority by the impugned order has regularized the suspension period by granting leave, extraordinary leave as due to the petitioner. As rightly pointed out by the petitioner, such decision of the competent authority would prejudicially affect the petitioner inasmuch as it would lead to complete exhaustion of the petitioner's leave to his credit and thereby deprive him of the benefit of leave encashment to which a government servant is entitled to on his superannuation. Thus, the above order entails adverse civil consequences on the petitioner. In such circumstances, it was incumbent upon the competent authority, in this case, respondent 1, to have afforded an opportunity of hearing to the petitioner before passing the impugned order. There was thus duty of to hear the petitioner under 54B before any prejudicial order was passed against him. Petitioner having not been imposed any penalty following a departmental proceeding and having been acquitted in criminal proceeding, with the sequence of events clearly demonstrating that the delay in the closure of the departmental proceeding cannot be attributed to the petitioner. It would be just and proper if the period suspension is treated to have been spent on duty and full fair allowances to be paid for the period. As noticed above, the respondent respondent 1 have failed to discharge their duty as per requirement of FR 54B. In such circumstances, this court is of the view that decision of the respondent to regularize the period suspension by granting leave is not justified. Accordingly, the petition is allowed by quashing that portion of the order dated such, regularizing the suspension period of the petitioner by way of granting leave, extraordinary leave. State respondent shall now treat the period suspension of the petitioner as period spent on duty for all purpose and pay the salary and allowances for the said period to the petitioner after deduction of the allowance already paid, my lord. Except that part, departmental proceeding in the thing, that is not in my case. They have done nothing in my case, my lord. So this is applicable to me, my lord. Now they have not passed any order. Now in page number 42, kindly see what order they have passed, my lord. Page 42. Middle. After careful consideration of the relevant records of the matter, the written representative of the officer, it appears that although Dr. Tapan Hazarika was placed in suspension, no departmental proceeding was drawn against the doctor. Not initiating departmental proceeding against the delinquent should not make such a person eligible for pensionary benefit. Strange. Also, the doctor showed no intention to join the government service from the date of suspension, my lord. Can I by forcefully join that? I wrote to them immediately, my lord. Then I came to the honorable court, my lord. Next, therefore, keeping in view the order of the honorable court, such the government health department is pleased to pass the following order to the present case. Dr. Topan Hajaraka is here reinstated in the government service from the date of taking over charge. Upon reinstatement, he is posted as medical health officer 1 at Dorong. Substance allowance is hereby granted to Topan Hajarika as per such and such. The period suspension from 2506 till the superannuation from the date of taking over charge in respect of Dr. Topan Hajarika as such will not be treated on duty for the pension purpose. That's what my lord kindly see.
When was he reinstated?
He was reinstated
When
on the
did he
date of
join?
my lord. Yes. He was reinstated on what my lord, this order is here, 1st of February 21.
Where is the order?
Page 42, that's the same page.
No,
Date-
where do you find 1st of February 2021?
In the page 42 bottom, reinstated. Bottom, 42 page number bottom, dates, Principal Secretary, Government of Assam, date 1st February.
No, when did he join? When did he join? From the date of, he is reinstated from the date of taking over charge.
Immediately, after getting this, immediate that date I think is
No,
not. But
I want the exact date. Without
is
that,
it-
no.
I'll give you the objective, my lord. In the meantime, I'll just ask the client. Put me the petition also, please check. Please, I'll get it. Then, my lord, this is my basic condition is this. Then there was a pair for allowance was not paid. Lordship has passed the order. We have got it, my lord. There's no problem about that, my lord. The next question is, my lord. So all these years, my lord, I have been kept like this hanging, my lord. Court is not attributed to me, my lord. Now, at least they should grant my permission. Now, they have filed an affidavit saying, my lord,
Where is the previous order of the court?
of the court, my lord. There's the lordship will page number 38.
Hmm.
Yeah. My lord, paragraph 8 to 21, he is joined, my lord. Paragraph, page number 10, para 9, first line, 8 to 21. Your petition states that he joined in the duties on 8 to 21.
Page number?
Page number 10, para 9, very first line. It starts 8 to 21. Now page 30.
So, what is the name of the petitioner?
Upon Hajarika.
Please come to page 42.
My lord, I know, that is the mistake. They're so careless there. Lordship has seen, I've seen that. See, second line, can you see? Second line, no dependent procedure, don't have against Pradip Kumar Kalita. My lord, it's a total non-reputation of mind, nothing else, the name is there. I've seen that. Total non-reputation of mind.
So your juniors have been promoted.
Juniors and senior associates, they have got promotion, my lord. They have become like, my lord, next post is senior medical health officer, then subdivision and medical health officer. To that level they come. So my fear is only that, my lord, they consider, my lord. I'm not saying, my lord, let the authorities consider, my lord, that's all.
Lordship, in this case, Lordship, regarding consideration of suspension period, Lordship, for promotion to the next higher post. The rule says that, Rule 11(2) of Assam Health Services Rules 1995 says that he cannot be considered for promotion as he has not served the required period of 5
Promotion
years.
will come later. How can you say that this period of suspension will not be treated for pension? On what basis?
That he has not served 5 years of service, Lordship, as medical and health officer.
No, the period, you have kept him under suspension for 14 years.
Yes,
There
Lordship.
is no departmental proceeding,
No, no,
no charge against him.
Lordship.
The order of suspension and continuance was found to be illegal, but
Lordship.
he has to suffer for that, is it?
Right, Lordship.
No, you are agreeable.
that
I
is
record
right.
your submission that you agree to this.
That is right, Lordship. No, sir, no departmental proceeding is there, Lordship,
Hmm.
against him.
Then why have you made him to suffer? Then if there was no allegation, no charge sheet, no DP, why have you kept him under suspension for 14 years? Now you are
As
saying,
as per instructions, I have filed the affidavit, Lordship. Again, I have received one,
what is your?
recently I have received one speaking order, Lordship. Kindly peruse this.
One speaking order.
Yes,
You have put in somebody else's name in his order.
Dated 29/10/24.
29?
10/24 recently.
Have you seen this, Mr. Nath? They
Yes.
disposed of your representative. Have you got a copy of this?
Yes,
Yes, I have given.
root cause and the problem remains the same. This is offshoot,
Same.
my lord. This is offshoot.
Yes, all right. Anything else?
And pension rule 61 also, my lord, the rate 54B of FR is also mentioned. So they shall have to act in pension rule 61. The FR 54 is mentioned. They shall be act as per about 54. It is there.
Let us see. Pension rules.
Rule 61. Rule 61. 61.
So, Mr. Nath, even if the order is set aside, the authorities will have to pass a fresh order.
Yes, that's why, yes, Lordship is right. I'm just thinking about that. That's why in this judgment which I have given, Lordship, the Honorable Judge has found that they failed to perform duties as per Rule 54. So instead of sending back to them, the Honorable Court was pleased to set aside, kindly see paragraph 21, my lord, of the judgment, my lord, of the judgment.
No, set aside is fine,
Yes.
but
And also Lordship held that in this case, that period should be treated on duty.
that is not
Yes.
permissible.
That,
I'm sorry, I disagree with that.
my
That
lord,
cannot be done.
my lord, I'm just, I also thought it about my lord, normally like case, my lord. In that case,
We would like to go
I
as per
understood.
the edict of law.
My lord,
The
Lordship,
law doesn't permit that.
my lord, I leave to lordship, my lord. I'm
The
also,
court can say that in these parameters, now they have to pass a fresh order.
yes.
But that order has to come from the authority, not from the court.
That's why I've gone through this, my lord, and I also felt it, my lord. As your lordship has felt, I too felt it. I leave to
Anyway,
lordship.
I'm not
Yes,
commenting on.
yes. Short time, lordship said that they failed to do, my lord, so that they pass an order that's on duty, like that, my lord. Because entire, if the free hand is given, they will pass the same order. No, you will not get pension, not on duty. So lordship, accordingly, my lord, pass the order. And that they can, for consideration of that other part. Parameshwar.
Okay, Ms. Bora?
Lordship.
Take down. Heard Mr. M. Nath, Learned Senior Counsel, assisted by Mr. A. particularly, Learned Counsel appearing for the petitioner. I've also heard Ms. D. Bora, Learned Standing Counsel, Health and Family Welfare Department, Assam, appearing for all the respondents. Stop.
Not for all the respondents,
Then-
Lordship. AG is there, Lordship.
For respond numbers
1, 2, 3, and 4.
1, 2, 3, and 4. None has appeared for the respond number 5. Although the name of the learned standing council for accountant general bracket A&E Assam bracket close has been duly reflected in the cause list. Stop. The speaking order dated 1/2/2021 issued by the Principal Secretary to the Government of Assam, Health and Family Welfare Department, that is the respondent number 1 herein, has been put under challenge in the present writ petition in the following, which arises in the following facts and circumstances. Stop. The writ petitioner herein was initially appointed as a medical and health officer on
My lord, is appointed on 14/12/04.
14/12/2004
Page 21.
and posted at Dhalpur,
Yes.
and posted at Bandarguri, Bandarguri, in the district of Durham.
Hmm.
Subsequently, the petitioner was posted as the
Yes.
as the medical and health officer dash number 1
Dholpur.
at Dhalpur CAC,
Looking.
wide office order dated 16/5/2005, issued by the respond number 2, full stop. While serving as the while serving in the Dhalpur CHC, the petitioner was placed under suspension wide order dated 02/05/2006, pending drawal of departmental proceeding. Full stop. Since the order of suspension was not reviewed and oblique or rebuked, despite the lapse of 90 days from the date of the order, and considering the fact that the request made by the petitioner to reinstate him in service was not acceded to by the authorities, the writ petitioner had approached this court by filing WPC number 959/2020, seeking a writ of mandamus inter alia for his reinstatement in service and also for payment of subsistence allowance. Full stop. After hearing the parties, WPC number 959/2020 was disposed of by the learned single judge by order dated 13/3/2020 with the following directions and observations. You'll get it in page 39, para 7 to page 38, page 39, para 7 to page 40, double tick. Full stop. Full stop. In terms of the order dated, next para, 13/3/2020, passed by this court, the matter was taken up for consideration by the respond number 1, who had eventually issued the speaking order dated 1/2/2021, reinstating the petitioner in service. Full stop. With service with certain conditions. Full stop. The operative part of the speaking order dated 1/2/2021 is reproduced herein below for ready reference. Page 42, Pama. Double tick to double tick. Full stop. Aggrieved by the direction contained in bracket or capital C of the operative part of the speaking order dated 1/2/2021, wherein it has been mentioned that the period of suspension of the petitioner with effect from 2/5/2006 till the date of his reinstatement shall not be treated as on duty for pension purpose. The instant writ petition has been filed. Full stop. It appears from the materials available on record that pursuant to the order dated 01/02/2021, the petitioner had joined back his duties on 8/2/2021, and since then is serving as medical and health officer posted at Mangaldoy, at Dhalpur CHC at Mangaldoy. Next paragraph. Mangaldoy, the grievance of the petitioner is that the respondents have illegally deprived him of the benefit of service during the period from 2/5/2006 till 8/2/2021, and has also failed to consider his case for promotion to the next higher rank of senior medical and health officer,
And subdivisional health medical health officer.
stroke subdivisional health
And my lord,
and senior health and medical officer and subdivisional
medical health officer.
medical
Yes.
and health officer, although his juniors stroke peers have already been promoted to the said rank. Full stop. The respondent number, next para. The respondent number 2 has filed counter affidavit contesting the claim of the petitioner. Stating that the petitioner has been paid the subsistence allowance for the entire period of suspension. However, insofar as regularizing his period of suspension is concerned, the same shall not be treated as on duty for the purpose of pension. Full stop. Next para. By referring to Rule 54B of the Fundamental Rules bracket FR, read with Rule 61 of the Assam Service bracket Pension bracket close Rules, 1969. Mr. Nath Lanet, Senior Counsel for the writ petitioner, has argued that since no departmental proceeding was ever initiated by the petitioner, and considering the fact that there is no finding in any proceeding initiated in accordance with law holding the petitioner guilty of any misconduct, the respondent number 1 was not justified in issuing the speaking order dated 1/2/2021 with a view to deprive the regularization of the period of suspension of the petitioner from the pensionary benefits, as such a recourse was clearly impermissible under the law. First up, by relying upon and referring to a decision of the learned single judge in the case of Dr. Isha Haq Mandal versus State of Assam and others, reported in 2013, bracket 2014, bracket 1, GLR 53, Mr. Nath has argued that the ratio laid down in the aforesaid decision is squarely applicable to the petitioner's case, and therefore the impugned order dated 1/2/2021, insofar as clause 3, insofar as the directions contained in clause C therein is concerned, be set aside by this court. Full stop. Responding to the above arguments, Ms. Bora has contended that the period of suspension of the petitioner from 2/5/2006 till 1/2/2021 cannot be treated as on duty, and therefore the petitioner's request for considering him for promotion to the next higher post also cannot be considered, since he has not completed the requisite length of 5 years of service as in the present post, full stop. Insofar as the primary grievance of the petitioner is concerned, Ms. Bora has, however, fairly submitted that in the absence of any departmental proceeding initiated against the petitioner, the impugn order dated 1/2/2021 may call for suitable review, may call for suitable review, full stop. Next, you take down. As has been noted herein above, the writ petitioner was placed under suspension on 2/5/2006 and his order of reinstatement came only on 1/2/2021. That too, in the wake of the order dated 13/3/2025. 13/3/2000.
Page 38.
One second. 13/3/2020, passed in WPC number 959/2020 as quoted herein above, full stop. No departmental proceeding was initiated against the petitioner, full stop. Therefore, the question of exonerating him from any charge of misconduct also does not arise in this case, full stop. As a matter of fact, there is no allegation of any misconduct against the petitioner as on date. Under the circumstances, can the petitioner be held to be responsible for the period during which he was placed under suspension? Question mark. The answer to the said question, in the opinion of this court, has to be in the negative. This is on account of the fact that FR 54B itself lays down the rule applicable in case of rule applicable to a government servant who is reinstated. Full stop. FR 54B is quoted herein below for ready reference. It all quote কৰিব লাগিব, huh? ইয়াতে পাব quotation আছে. Full stop. The right of a government servant. No, you're right. Right or not? From a perusal of FR 54-B bracket of 3, numerical 3. On reinstatement in service, the government employee shall be entitled to full pay and allowances if the authority competent is of the view that the suspension was wholly unjustified. Full stop. In the present case, there is no mention in the impugn order dated 1/2/2021 that the suspension of the petitioner was justified in the facts of the case. Full stop. As a matter of fact, such an opinion perhaps cannot even be expressed by the competent authority in the facts of the case, in view of the fact that there is neither any allegation brought against the petitioner nor any proceeding initiated so as to establish such allegation. Full stop. Therefore, the writ petitioner, therefore, it cannot be said that the suspension of the petitioner was justified full stop. Be that as it may, as per the provisions of FR 54-B bracket 3, it is for the competent authority to take a decision in that matter. But full stop. But in the present case, comma, as has been noted here in above, although no such opinion has been expressed, yet the petitioner has been penalized by including the direction in clause capital C, bracket or capital C of the speaking order dated 2/5/2006. Full stop. Such being the position, this court is of the unhesitant opinion that the impugned order dated 1/2/2006, insofar as this same relates to the directions and observations contained in clause C, are wholly unsustainable in the eye of, is wholly unsustainable in the eyes of law. Full stop. Therefore, this same is set aside. Full stop. Insofar as no, it is also to be noted herein that the right of a government employee to receive pension is governed by the provisions of Assam. Right of a state government employee to receive pension is governed by the Assam Service bracket pension bracket close rules 1969. Full stop. Rule 61 of the rules of 1969 deals with the right to receive pension in case of those employees who were suspended pending inquiry. Full stop. Rule 61 is quoted herein below for ready reference. Full stop. Even from a bare reading of Rule 61, it is clear that unless the conditions stipulated in Fundamental Rule 54 is complied with in letter and spirit, no order can be passed against any government servant stating that the period of suspension will not count for the purpose of pension. Full stop. Next, in the case of Dr. Isha Haq Mandal, bracket Supra, relied upon by Mr. Nath, a similar situation arose wherein an employee was placed under suspension, and although departmental proceeding was initiated against the employee, the same was not proceeded further. Full stop. Taking note of the mandate of FR 54B and the facts of the case, as well as the fact that no penalty was imposed upon the petitioner therein, the learned single judges observed that merely because there was delay in closure of departmental proceeding, it would not be just and proper to treat the period of suspension of the employee as not in duty. Full stop. Accordingly, a direction was issued to treat the period of suspension of the employee as on duty and pay her the full pay and allowances. By observing that the authorities had failed to discharge their duty as per the requirement of FR 54B. The court had made the above observation by taking note of the fact that the period of suspension of the employee was regularized by the authorities by granting leave stroke extraordinary leave, which was detrimental to the interest of the employee. Full stop. In the present case, not to speak of dropping any departmental proceeding, there was no proceeding at all initiated against the petitioner. Under such circumstances, the petitioner cannot be held liable in any manner for the period during which he was placed under suspension. Full stop. The observation in the impugn order dated 1/2/2021 to the effect that the petitioner has shown no interest to join back his service is also found to be wholly untenable in the eyes of law, more particularly in view of the fact that it is the petitioner who had approached the court by filing WPC number so-and-so seeking reinstatement in service, and therefore it cannot be said that the petitioner was not interested in joining back his duties. Full stop. In this writ petition, the petitioner has made other prayers, including prayer to consider his case for promotion. However, unless a fresh order is passed by the competent authority in the light of FR 54B, such a claim of the petitioner cannot be adjudicated in the pending proceeding. Full stop. In view of the above, the writ petition stands allowed to the extent indicated above. Upar divo, the impugn order dated so-and-so, insofar as the directions and observations contained in clause C of the operative part is hereby set aside. The writ petition stands allowed to the above extent. The respondent number 1 is directed to pass a fresh order in terms of FR 54B, read with Rule 61 of the Pension Rules of 1969. In the light of the observations and directions made herein above, the aforesaid exercise be completed within a period of 60 days from the date of receipt of a certified copy of this order. Full stop. Subject to the order that may be passed by the respondent number 1, the claim of the petitioner for considering him for promotion be dealt with and considered in accordance with law. Writ petition stands closed.
Only one time frame may be given, my lord.
Huh?
One time frame may kindly be given.
60 days.
My lord. And my lord, subject to correction, probably about 7, 8 or 9, 10 page, lordship has date 1206 should be 21. Let me check.
We'll check. There may
Yes,
be a
my
little.
lord, oblige, my lord.
Admission is over. Admission is over. They are deciding the court proceeding or me? Court কোনটো আছে? Serially you should have followed. Ask me. Backing this. So, Mr. Chaudhary, it has to be heard finally.
Yes,
When?
not today, my lord.
So is it an admission? You don't want to file any affidavit in?
I think pleadings are there. Well, a very short point is involved. Isn't it? If it is otherwise inconvenient, we can have it another day.
No, not inconvenient.
Yes. My lord, a very short point is involved. My lord, normally when it comes to filling up vacancies, we know, or rather the Supreme Court has said, what can be filled up is the existing and anticipated vacancy. Now, the issue which falls for consideration here is, my lord, whether apart from existing and anticipated, future vacancies can be made. Future vacancies can be also filled up. That is one. And number 2, this principle is normally synonymous with direct recruitment. So whether this principle applies to a case of promotion also. These are the 2 issues which are involved in this case. Now, if your lordship kindly takes the writ petition, your lordship would kindly have item number 5. Pass to the option. My lord will kindly come to page 30. This is the advertisement which was issued on 3rd of May 2018. Applications are hereby invited for the Assam Local Fund Audit Service promotion examination to be held on the dates to be notified later on for filling up 32 number of posts, including backlog vacancies reserved for SC/ST candidate of audit officers, local fund, Assam, in the revised pay of so and so, so and so, so and so. Now, if your lordship will kindly come to serial number 8, my lord. The filled-in application accompanied with necessary documents must reach the office of the APSC on or before 4/6/2018. So this date has a relevance. That's why I have referred to this date, my lord. Then please come to the next page, page 31. Serial number 12. The current reservation and backlog vacancies against 32 number of posts as maintained on the basis of the post-based roster wide notification dated will be as follows. STP 3, STH 4, SC nil, total 7 reserved category and 25 open category, total 32. So this is the situation, my lord. Now, if your lordship should kindly come to page number 38. Now, normally, my lord, if we go by the language of the rules,
Yes.
when an advertisement is made, it already takes note of, my lord, existing and anticipated vacancies. The future vacancies cannot come in. Now, please come to page 38.
Yes.
With reference to the above, I have the honor to state that Assam Public Service Commission had conducted a written examination for filling up of 32 posts of audit officers on promotion from assistant audit officers with effect from 22/2/19 to 23/2/19, who had at least 3 years of qualifying service. There were 80 such qualified assistant audit officers who had appeared in the aforesaid examination. It may be mentioned here that at the time of advertising the post of audit officers, there was a vacancy of 32. Currently, the vacancy has risen to 51. Though originally it was proposed to fill up 32 number of posts of audit officer, it is now required to fill up all existing vacancies, considering the requirement of the director. So, my lord, what is very established is that examination had already taken place on 22nd of February 2019, and 80 qualified assistant audit officers had participated in the selection process. Thereafter, certain vacancy arose, precisely 19, because if we add the 19 to 32, then it becomes 51. So therefore, a request was made that this should also be included. And
But
this is how
your clients could not participate in that.
No, our client participated, my lord, but we failed. Because that is again another aspect, I'll come to it. We could not secure the required marks. But then there is a concept in the rules, my lord. In the subjects where we have cleared, in the next time we don't have to appear. Our prayer is, my lord, the vacancies which have arisen now, that is 19, it should be advertised afresh. It can be filled up by the impune advertisement of 2018. Now, my lord will kindly come to page number 39.
Yes.
The APSC has came out with a select list of 57. Page 39 and 40. Now, as far as the position of the petitioners are concerned, my lord, please come to page 41. 7th of November 2019. With reference to your letter cited above, I am to say that 80 number of candidates appeared in the above mentioned examination, which was held by the commission on so and so, so and so, so and so. Recommendation of which has already been sent by order letter dated so and so. Now I am sending the name of 14 candidates mentioned below who secure exemption marks in one or more subjects in the Assam Local Fund Audits Service Exam Promotion Examination 2018. So, my lord, the papers which we have cleared, will in the next exam we need not appear again. So this is the position, my lord. So now we made a challenge to the appointments beyond 32, promotion beyond 32. Initially, there was an interim order passed by the learned single judge. The learned single judge says, for the present, you confine the selection promotion exercise to 32. That was challenged by some of the selected candidates before the division bench, my lord. Division bench modified the order and the matter was remanded to the learned single judge or your lordships to decide the matter afresh. But never appointment to Diana, no? But the department has not, my lord, permitted them to join the promotional post.
Not even the 32.
Huh? And now fresh advertisement has also been issued. Na? Yeah, that is the position.
No, even the 32 have not been allowed to join.
No, 32 have been. Beyond 30.
Beyond 32.
Yes. Now, my lord, the essence of the private respondent's case in the division bench was the principle that only existing and anticipated vacancies can be operated is normally confined to, my lord, direct recruitment, not to promotion. But then Supreme Court has said, my lord, this principle applies everywhere. Now I'll place two judgments. This is the only facts, my lord. Now I'll place the rule, then the judgment, my lord. Now, rules has also some significance in this case. Rules of copy that yes. Full copy that yeah. Well, there is a set of rules framed under proviso to Article 309, which governs the recruitment.
Yes.
Now, my lord will kindly come to Rule 17 at page, I think, 118 of that gazette. Promotion through departmental examination.
Just 1 minute. Yes.
Promotion through departmental examination. Promotion shall be subject to the following reservation. 75% of the vacancies in a year of recruitment in the cadre of audit officers shall be filled up by promotion of assistant audit officer who qualify in the departmental examination called Assam Local Fund Audit Service Promotion Examination. Now, please come to sub-rule 3, my lord. Assam Local Fund Audit Service Promotion Examination shall be conducted by the Commission in accordance with the rules and syllabus as in Schedule 3 and shall be held at such interval as appointing authority may, in consultation with the Commission from time to time, determine. A list of candidates who have qualified in the said examination shall be prepared by the Commissioner in order of merit and forwarded to the appointing authority. Promotion shall be made from the list subject to availability of vacancy. This is very significant. Even if the list contains more names, subject to availability of vacancy only, the promotions are to be made. So vacancy was 32. There's no question of filling up 51 or 57.
32 as on the date of issuance of the
Yes.
advertisement.
14/6/2018 was the last date of submission of application form. Whatever vacancy has occurred prior to that, that can be filled up. No vacancy beyond that can be, included in the present promotion exercise. That is our case, Milord. Anjana, yes. Now, Milord will kindly come to Rule 20, Sub-Rule 3. Page number 120, Milord.
Yes.
The subject to the provisions of Sub-Rule 2, appointment to the cadre of audit officers shall be made in accordance with the order determined by the Commission in the list referred to in Sub-Rule 3 of Rule 17 and in sub-rule 2 of Rule 18. 2. Inclusion of candidates' name in the list shall confer no right to appointment unless appointing authority is satisfied after such inquiry as may be considered necessary that the candidate is suitable for appointment to this service. Appointment shall be further subject to availability of vacancy. So here also, my lord, the rule position is very clear. Merely because somebody's name appears in the select list, that by itself will not, confer any right. 3. The list of departmental candidates for promotion to the cadre of audit officer under sub-rule 3 of Rule 17 shall remain valid for 12 months from the date of approval of the commission. So, my lord, my humble submission would be, if we read the Rule 17(3) harmoniously with Rule 22, my lord, and 3, what clearly emerges is only available vacancy, that too again relatable, my lord, to the advertisement and the last date of submission of application form. Those alone can be filled up. There is no way, my lord, we can give any meaning to the rule whereby any future vacancies can be comprehended.
This promotion is to be given only to departmental candidates.
Department.
Then why open advertisement was issued?
The rule itself envisages this. Rule itself envisages, my lord, that there will be a selection and based on the list prepared by the
No, I
commission.
understand. What I'm saying, if it is amongst the departmental candidate, so normally a open advertisement.
That in a, yes, my lord, the view can be taken via an advertisement. That's possible. Now, my lord will kindly come to the schedule just to appreciate our perspective. Why we say that the having secured the exemption mark, there are certain benefits to us. Please come to page 132, my lord, the part of the schedule. On top, no books will be supplied for any paper. Any candidate failing in the examination but securing exemption mark in a subject will not be required to appear again in that subject. So, my lord, we having secured exemption mark, this is the benefit which the rule conferred.
So now you want that the fresh advertisement has been issued.
Yes, beyond 32.
When was the date? When
Yes,
was the advertisement?
yes, I'm giving the dates.
Is the copy available?
Yes, yes. Advertisement is there, or fresh advertisement. Assets.
That is under challenge on item number 3.
That we have. এইটো কেইটা পোস্ট কৰিছে এতিয়া এইটো কোন এইটো ইনক্লুডেড হয় না নহয় আমাৰ কেইটা আচ্ছা আমাৰ পাৰপাস সার্ভে
So total post 36.
53 I think
53. 53, yes.
That-
Now this 53
open
includes.
category is 36 and I think reserve category 5 plus 8 plus 4 12
This
plus
53, does it include the 25 from the previous?
No, that position department will have to clarify.
Just,
It appears, Lordship, from that affidavit.
no, wait, you have to give a concrete answer because.
Lordship, in the list submitted by the department in its latest affidavit, Lordship, after 2019, the remaining posts up to 2019 and the vacancies up to 2023 is 53.
My lord, one thing is very clear. If my learned friend makes that statement that if the fresh advertisement includes the post beyond 32, then my lord Rosim need not answer the writ petition. That is our prayer. Everything depends on what the government says.
Mr. Nayak, we'll look for a little clear, specific and categorical answer.
Lordship.
Your advertisement is of 2017, the previous one. There is a last date of submission of application. Let us for a moment accept what he's saying, that 32 vacancies were there. In fact, that is also the projection in your affidavit.
Lordship.
Let us accept that the court holds that 32 and no further under the previous advertisement. Then in that case, will another 25 be added to the 53 or this 53 includes the 25?
Lordship, up to 23, this is the entire list. And out of this entire list, 32 appointment has been given.
So minus 32, whatever is
It
there.
is 53.
It is 53.
Yes, Lordship.
Then your writ petition is.
Answered, yes.
It's also,
Answer.
only writ petition that remains is his. The other one, what else is there? You have accepted their stand.
No, but this advertisement is under challenge.
Huh?
This
Not at our
advertisement is under
instance.
challenge.
That's what I'm saying. These two writ petitions are over. Not understood.
No, understood, Lordship, but
You have conceded to their case.
By including the
Yes.
post in the phrase advertisement.
but if Lordship goes through the schedule, Lordship, strength of the
We'll
cadre.
go through it in the
Strength
next
of the
round.
cadre, Lordship.
If 53 includes the 25 out of the
I am
57.
not specifically answering that,
Then
Lordship.
you have to answer it.
I am only saying from the table annex with my affidavit,
But
Lordship.
you have to give that answer to
Yes,
them. You don't have it today is another thing.
Lordship.
But you have to say whether it includes or not.
But as on date, cadre strength is 159.
Dependency of this writ petition. Without the leave of the court, you have done it. Is it not?
That is true.
Then, when this matter was sub judice, you take one stand before the court and you means not you individually,
yes.
but the department takes another stand. What is the court supposed to think about this? Tell me.
Yeah, Lordship, that specific answer, Lordship, I can check from the department, Lordship. Whether this 53, this, I mean, this 19, no, 22. Yes, whether those posts prior to 2019 include.
51, na?
List was 57,
50 can appointment 51.
90 of 32 KDS.
So out of 57, if 32 have been given,
Yes,
and you said that total vacancy was not 57, it was 54.
54. Up to
So that
2019, it
22
was,
vacancies were there even at that stage.
yes, Lord.
Then subsequently more vacancies arose.
Yes, Lord.
So 22 plus 31, then only it becomes 53.
53. And that 53, the number in the
Correct.
advertisement,
So,
that is what only I'm saying.
If those 22 years included in 53 and you have issued this advertisement without the leave of the court,
No,
these writ petitions are answered. We'll close it as answered. What happens to the other writ petition, that we'll see. That is the only, why should we keep these pending then? Mr. Nayak, have you understood the question?
yes, Lord.
On 19th as fixed parted matter, so as to enable Mr. P. Nayak, you are appearing as
Standing Council, Finance Department.
Standing Council Finance Department to clarify as to whether the 53 posts advertised through advertisement notice number 20/2024 dated. What is the date of the advertisement?
Second one, Miller.
Yes, second one.
16 September 24.
16/9/2024 includes the 22 vacancies which would not be filled up as per the previous select list due to the pendency of these proceedings. The written instruction on this behalf be placed on record on the next date fixed, 19th?
Can be 21st, 19th.
21st, okay, 21st?
Yes, Lord.
21st?
I thought there's a family marriage on 21st. Could it be after 24th, Miller?
Let it be on
Or let
21st.
it be, in case of anything, Lordship will accommodate. How about that?
No, but if they have done it,
Then, my lord, my
we'll
petition
close their
stands
two writ
answered.
petition, and then his writ petition
Yes,
will only
yes,
be heard.
yes.
Whether we do it on 21st or.
Yes,
that we'll
yes.
see.
If it is done, my lord, my writ petition, that's not only prayer.
In item 3, my lord, in fact, that is our specific prayer, that we are entitled to under the previous advertisement, and that should be implemented.
But your writ petition is infructuous.
No.
Have you challenged this?
Yes.
This is of September.
Yes,
That is
that
under
is not,
challenge.
and in fact, there is an interim protection.
New
Order
advertisement
passed-
is under silence.
Your lordship has passed an order allowing them to proceed, but not to file.
In
Your
that case,
petition-
both the petitions will have to be disposed of together.
All right. Let us get the instruction.
Yes, first hurdle will be that.
Item 9.
May it please your lordship. My lord, the petitioner who was working as my lord woman constable, my lord, is challenging the order of removal from service, your lordship, as well as my lord order passed by the appellate authority, your lordship. On the ground, my lord, on that, my lord,
What, this is a removal from service. You got the records?
My lord, record has to be put in, my lord. I will need some time, my lord, to get the records, my lord.
What is the date of the order?
my lord, the removal from service order is 16/5/2023, my lord.
There is urgency. We'll admit it and fix it for final hearing. You produce the record.
In place, if, my lord, in admission hearing.
No, that will not be done. These are all aberration of the system. Then why have hearing matters at all? And they are not bound to produce the record unless it is fixed for hearing.
Date, if we not
A
in.
date we can give. You choose the date.
Whatever date, my lord.
All right. Your convenient date you can
My
mention.
lord,
Dismissal from service matters will be fixed for hearing in this court because that is the norm. The problem is this court goes by the norms.
my lord.
Either you say that the norms are not correct or you'll have to follow it. That's the simple answer. Hearing matter, these are rule nisi. They
Otherwise,
are
on
bound to
my lord.
respond only when a rule is issued. Admission is not a rule.
My
It
lord,
is a
that's-
notice.
my lord.
When a matter is fixed for hearing, the court issues a rule nisi.
My lord.
And if they do not respond to it, the consequences they will face. But in an admission matter, the government advocates don't know. Even if a petition is allowed, they are entitled to get it set aside only on the ground that without issuing a rule, the court has set aside or quashed our decision. Thank your stars that the government advocates are not conversant with the law. Otherwise, all these matters disposed of, this
By issuing rule
dismissal, order of these orders, all of this can be challenged in the division bench or higher forum only on this ground. That's why I not
That's
pass
why,
this.
my lord, in the Bombay High Court judgments, I used to see, my lord, that rule has been made absolute without giving.
Thank
detailed-
your stars that many things are happening because people are ignorant, whether it is this side or that
Earlier,
side.
my lord, that was the, my lord, norm.
No, but you don't say that. You are also agreeable to a disposal at admission stage. These are all final orders which the court has to issue a rule, get an answer, set it aside, issue a mandamus, quashing it. And these matters are being disposed of in admission stage. Nobody raises any question. I have seen it happening. All these orders are illegal.
Earlier, that was the norm, my lord. Rules were issued and then-
That's the problem.
Sometime
In
rule
this
is
court,
returnable
you
forthwith.
either
also.
have to say that the understanding of the court requires correction, which I am open to, or comply with it. It can't be that, okay, the rule is this, but please do this for me. That will not happen here. What do you want?
My lord, your lord, only date so that because she's only 32 years, my lord. So
That even before you said, but the date will be in January.
January.
Then you could not answer. When twice I have asked, you could not.
My lord, in the month
So
of
then it has to go.
December or.
Your right is forfeited. I asked you twice. You
My
said
lord,
any
I
date,
was
any
supposed
date.
to say, man.
Anyway, you take down hard Mr. A. Goyal and counsel for the writ petitioner. Peruse the amendments made in the writ petition. The petitioner is before this court by filing the writ petition, assailing the order dated. What is the order of dismissal?
16/5/2023,
by means of which she was dismissed from service.
Removed from service.
Removed from service, as well as the subsequent, no, removed from service. Full stop. I have perused the grounds taken in the writ petition. Issue rule returnable on. When do you want it?
My lord, November or December, your lordship. This year, my lord, so that.
10th of December 2024. Since Mr. A. Dhar, learned additional senior government advocate, R. Dhar, learned additional senior government advocate Assam, is present on behalf of all the respondents. No further notice is required to be sent in this case. Considering the urgency expressed in the matter, this writ petition will be taken up for final disposal on the next date fixed. The learned departmental counsel to come prepared with the departmental records. Uh, Anything you want to say?
No, my lord. I'm not hearing and your lordship has fixed it on 10th, my lord. I'm happy. Deeply obliged.
Lordship, in this matter, we request some more time to take the instruction, Lordship. Instruction, compulsion appointment case, Lordship.
What is this matter about?
Your lordship recommended by the SLA long back in 2023, lordship. Others have been appointed along with this petitioner, not this petitioner.
Gaon Pradhan.
Compassion appointment.
Compulsion appointment.
Compassion.
This is physical disabled person, lordship.
So 8 out of 8, 7 you have appointed.
7
You have left-
appointed at, but as per this petition page 31, Lordship. Kindly come to page 31. Point B, the say the SLC thoroughly examined all details of the following candidate who has locomotor disability and requested Forest Environment Forest Department to explore the position of vacancies in other administrative department, Lordship. So we are exploring the vacancy position other departments, Lordship. That's instruction way to take.
To accommodate the
Yes,
petitioner.
yes, because while providing an early appointment to
All
the
right,
candidate.
Mr. J. Kalita, learned counsel is present for the petitioner and submits that although the authorities have appointed 7 out of the 8 similarly situated candidates, the case of the petitioner has not been considered, thus extending a discriminatory treatment to him. First up, responding to the above, Mr. R. Gogoi, learned standing counsel for Forest Department submits that the departmental authorities are exploring the possibilities of accommodating the petitioner against a vacancy. And therefore, 4 weeks further time is required for him to obtain concrete instruction in the matter. First up, from the submission of Mr. Gogoi, it appears that a move is afoot to accommodate the petitioner in a suitable vacancy. Full stop. In such circumstances, this court is inclined to grant some more time to the learned departmental counsel to obtain instruction. Accordingly, this matter is directed to be listed again after 4 weeks.
Obliged, Lordship.
You want a copy of this order?
I'll get from the. Okay.
For hearing, item 11.
May it please your lordship.
Yes.
My lord, the petitioner before your lordship participated in a selection process conducted by the respondents for the post of Assistant Revenue Officer. 3 posts were advertised, my lord. Subsequently, he was jointly placed at serial number 5th position, my lord. Eventually, my lord, under some RTI, we could learn that the member secretary of the Viva Post Committee is the father of private respondent number 7, who has been selected, my lord. So, my lord, as your lordship knows, the Honorable Supreme Court in Katanov decision has held that, my lord, he could not have participated in the selection process in any manner. So, applying the doctrine of bias, my lord, in my humble submission, the impugn selection VCS. Your lordships come up to page 13. This was the advertisement, the writ petition.
Page
13, 1-3, lecture 1.
Yes.
So this was the advertisement, my lord. Amongst others, there were other posts also. We are concerned with the post of my lord ARO, that is the Assistant Revenue Officer. Then, my lord, the Karbi Anglong Autonomous Council, DIFO, at page 15, my lord, 1-5. Next page is annex up to page 14. Is the select list
So
where
there were a number of posts.
Number
You're
of posts.
concerned with ARO.
ARO, man, Eastern Revenue Officer. 3 posts are advertised for ARO. And Lord, we kindly come to the next page, page 14, annex 2.
Page
Written-
14.
Yes, written examination was conducted and results were declared. My lord, the petitioner is from the top, serial number 4. He cleared the written examination along with the private respondents. Dilshan Terang. 1, 2, 3, 5, fifth position. Thereafter, my lord,
This is all what, in order of merit or in order of roll number?
my lord, these are all, it's a random, my lord, probably not in order of merit. But we'll kindly turn to the next page. This is very important, my lord, page 15. The respondent authority, that is the Karbi Anglong Autonomous Council, DIFU, constituted a Viva Voce committee for conducting the Viva Voce, the interview part, my lord. And Lordship will kindly see serial number 2, Sri Dhaneshwar Inti, that we have made him a party as respondent number 7. So he has been, my lord, appointed as member secretary of this Viva Voce committee.
Member Secretary of Viva was a committee.
Yes. Thereafter, my lord, the interview was conducted and my lord, 3 candidates were appointed. And out of that, my lord, respondent number 10, who is the son of this serial number 2, Dhaneshwar Inti, has been appointed by me. Next page is the select list, my lord, at page 16. Page 16 is the list of candidates who were selected. Nilutpal Rahang, he secured the first position. Jojo Terang secured the second rank. Longpi Ingti, that is the respondent number 10 here, he secured the third position. So there are 3 posts. These 3 persons have been appointed. And my lord, the 4th position secured is the daughter of this serial number 2, the member secretary. And Basabit Tenongpi and Jijo Terang, my lord, Jason Terang. So at serial number 6, the name of the petitioner appears, and he has secured the 5th rank jointly.
So what is your prayer here?
My lord, my prayer is that since the father of one of the selected candidates have participated in the election process, the law of the land envisages that
No, we will go to the law later on. What do you want?
I want the selection to be set aside, my lord.
Selection, all the 3 candidates.
Yes, in respect of respondent number 10, the father has participated. And in respect of the candidate who has secured the first position, that is the respondent number 8, my lord, interesting thing has happened. I have annexed all his educational documents. The spelling in the educational documents does not match the spelling with the answer sheet he has submitted. Answer sheet also have. It's highly unlikely that candidate will write his name improperly, my lord. So in my humble submission, probably some proxy candidate appeared for him, my lord. all educational documents I have annexed, placed before this honorable court. The spelling is different, but in the answer sheet of this examination, the spelling is different, my lord. So that is one of my contentions, subject to what your lordship say. So for these two candidates, I am at least assailing, my lord.
You are?
I am assailing their selection, my lord.
And what about the third?
Third, my lord, I have said that in his answer sheet, my lord, there was a question writing of a letter. He has disclosed his name there, my lord. Answer sheet I have annexed. On one of the answers, he has disclosed his name. So the evaluator knew whose answer sheet was that.
No, but you can't be appointed.
I can be, my lord.
They will be set aside and you should be appointed.
Yes.
How?
Fourth candidate is the daughter of that, my lord, member secretary. Fourth candidate cannot be appointed. I have made her a party. The candidate placed at serial number rank 4. She is the daughter of that same member secretary.
But has the respondent number 10 been interviewed by the respondent number 7?
No. Respondent number 10 was not interviewed by respondent number 7. But will that be enough, my lord? But not taking interview of his son, will that absolve him from, my lord, the test of bias, my lord? The Honorable Supreme Court says no. He has to completely abstain from the selection process. That is what the law mandates. Yes, in case of statutory body, like a public service commission, where the appointment of a member is done through a constitutional process, then the issue would be different. But in all other cases, merely intimating the authorities about a son or a daughter appearing in an examination will not absolve that particular fellow from the test of reasonableness.
But he has informed.
Now, my lord, pursuant to a lordship's order, lordship was pleased to hear the matter on an earlier occasion. Lordship directed them, and now, by way of an additional affidavit, they produced a letter that he has informed. My question before this honorable court is whether this intimation is enough or not. And I will show your lordship from our honorable Supreme Court judgment that it is not enough.
Now, what is the position? They have been appointed.
They are working, my lord.
They are working.
There was a criminal case also on the same aspect of pilot that has been in another aspect, but this is going on from 2015.
And what has happened in the criminal case?
Criminal case. Acquitted.
So these people are working since almost last 7-8 years.
Yes.
And you have not applied for any other post.
My lord, I am also working, but
You are working somewhere.
yes, well, I am working somewhere, but my lord, I have immediately assigned a selection at the very relevant point of time, my lord. It's not that I have come belatedly before this honorable.
No, that's another matter. But what post you are working now?
My lord, I will have to take instruction, my lord. Exactly, I am not aware.
No, Mr. Patwadi,
My lord.
It's not that the court is not appreciating your arguments.
My lord.
But, and maybe there are a few things totally unacceptable.
My lord.
But as a REIT court, as a court of equity, the court will always have to take a holistic view in the matter.
True,
and equity will always play a role. It's not that court is rejecting your argument or accepting or rejecting theirs. But we have to be equitable in our approach. Therefore, it is important to know where is he placed. Today, if this is not a PIL,
yes,
if he is equally placed in another government job, then he may not like to even join here. So why should we do this exercise at his instance? That is also that will be a relevant factor. And so many years have gone by.
I have understood.
And he can't get in. That answer I am giving you. So why do we do this exercise? Of course, there are ways and means of looking at things. I don't say that law should make a distinction, but many things in Maharashtra or Delhi setup will be very little different from things happening in nooks and corner of Northeast. So the courts have to be conscious about this thing. Yes, this cannot come in the way of determining rights. If there is a strong right, then whether it is London or Maharashtra or Karbi Anglong, same principle. But if it is a gray area where we are also not sure what does he stand to gain, then we will have to take a pragmatic view in the matter.
True, my lord.
Hope you understand that.
Yes, ma'am. I'll
So
take the
therefore-
instruction, my lord. Also kindly accommodate me, my lord.
We'd like to know that which post
Of
he
course,
is
of course.
and what is his pay scale. Is it?
Yeah, I have understood. Whether it is equivalent to this ARO or not.
That's right. If that is the case, then why should this exercise be done? That's this whole question here. Because we have to, we're conscious that many years have gone by. Some of these candidates may have crossed their age also, who knows. If he was not appointed, the matter would have been slightly different. You let him find out then.
Right.
Mr. Kulit. Let him. Why don't you also get the instruction? Both of you get it.
He's working by, he's working in now the government of Assam, you have state sector, you have forest department, posted. Office of the minor. Range office.
Is it the same grade as ARO?
Pay scale, my lord, the state pay scale, my lord, there is a council pay scale, it is not the state government. Yeah, my lord, home pay scale. Nothing, there is nothing mentioned on any other very. It's a better position now.
I'll take the instruction.
That is my lord,
You have to file a affidavit that you'll give up your job. All right. Put the appearance, please. After hearing the arguments,
He is now working in the range forest officer, my lord. Tobuna, na Valley, my lord.
range forest officer will be more lucrative. Then
I'll obtain the instruction, my lord. Kindly give me some time.
it has become necessary for this court to ascertain as to whether the petitioner has accepted government appointment in any other post, and if so, whether he is still interested to pursue the matter in the right earnest. Mr. Patwari prays for and is granted how much time?
1 week.
2 weeks time to seek concrete instruction from his client on the above aspect. This is the matter accordingly.
Simply.
Milord, the issue relates to whether these petitions, not all, by now, only there may be 28 only, 24, are entitled to the regular status in the service. Whether they are entitled to be treated as a regular employee by now, and they have a right to that extent. And the authority has no other option but to regularize them, give them regular salary, take them as the regular employees of the department. What happened here? They are all diploma holders, engineers, civil engineers. They were recruited as accredited engineers under the Panchayat and Rural Development Department. That was that by following the due process of selection after advertisement, written test, everything was done and they were seen. But they were appointed on contractual basis. Right? They were appointed on contractual basis. It was in the year 2010. Until now, they are all working without the interference of any, continuously. They are paid the fixed salary. But they are discharging the duties which are normally done by the junior engineers of the department. Post of junior engineers were sought to fill up. There were posts. Those posts were advertised. We approached this honorable court that first let them consider our case. Court in earlier occasions directed the authority to consider and evolve certain procedure to accommodate them. The authority ultimately decided that they are entitled to be considered and absorbed by following the process of law. And they issued an executive order. I will straightway take your lordship first to that order. Lordship will kindly peruse at page 78.
Page 72.
78.
78.
Annexer 12, maybe? Isn't it? Huh?
It would work. Yes.
কোনটো? এইটো নহয় জানো? 14th August? 14th August, হয়, চাম ৰবা। Here, Lordship will see. This is an executive order, they call it. Dated 14th of August 2020. Lordship got it, my lord?
Yes.
Number so and so. In pursuance of the Honorable Guwahati High Court's order dated 21/7/2020. First in WPC number such. In the matter of all Assam Accredited Engineers Association. That time the case was fought by the association. Represented by so and so. State of Assam so and so. So and so. Assam Panchayat and Rural Development Officers Technical Service Rules 2015, which confers the power to the government to dispense with or relax their requirement of any provisions of the rule if the government is satisfied that the operation of any of the rules cause undue hardship in any particular case. The Governor of Assam is pleased to make the following subsequent order in respect of filling up 354 numbers of post of junior engineer civil under Panchayat and Rural Development Department, which has already been published by the State Public Service Commission, so and so, dated 24/6/2020. Necessary approval of Finance Department has been obtained, and in pursuance of the same government in PRD department recorded approval for filling up the vacant post. There are a large number of contractual accredited engineers under PNRD department who were recruited through proper selection process and who have rendered long years of service in the department. And after such long exposure, specific service in their respective assigned jobs, they have evolved as trained manpower of the department for implementation of various rural development schemes in the department. The PNRD department, while filling up the above vacant post, proposes to give preferential treatment to the eligible contractual accredited engineers of PNRD department. This is very important, my lordship will kindly note. The following.
So, Mr. Mohanta, just sorry to interrupt you for a minute. Your clients are all accredited engineers who were appointed sometime in year 2010 on contractual basis. And since then they are continuing. The contract is being renewed from time to time. What is the relief you are seeking here?
Now, at the moment, I am seeking the relief that we are entitled to get the regular status. And we should be treated as a regular employee against those vacant posts. This is my case at the moment.
Is there any Decision, Supreme Court decision on that point.
There is a decision of in Vinod Kumar's case in January 2024, exactly on similar
Let
facts.
us see.
Lordship will kindly consider that they have not only evolved in their service, but their rights have also evolved accordingly. And
Which is the relevant paragraph? Let's see.
yes,
Have you seen this judgment, Mr.?
No.
No, if there is a judgment and if it applies, then fine.
in my respectful
Otherwise,
submission, in my respectful submission, it would ease my task. Lordship will be pleased to find that these interpretations are equally applicable considering the facts and the law the apex court has interpreted.
if it
So-
does, then certainly.
Yes, then my lord, I will take your lordship, my lord, to the entire judgment so that it will be clear with the facts.
But first the relevant part, then we'll go through the entire judgment.
5,
Yes.
paragraph 5.
Paragraph
Having heard the arguments of both the sides, this court believes that the essence of employment and the rights thereof cannot be merely determined by the initial terms of appointment when the actual course of employment has evolved significantly over time. The continuous service of the appellants in the capacities of regular employees performing duties indistinguishable from those in permanent post and their selection through a process that mirrors that of regular recruitment constitute a substantive departure from the temporary and scheme-specific nature of their initial engagement. Moreover, the appellant's promotion process was conducted and overseen by a departmental promotion committee, and theirs sustained service for more than 25 years. They were more than 25 years. We are 14 years. Without any indication of the temporary nature of their roles being reaffirmed or the duration of such temporary engagement being specified, merits a reconsideration of their employment status. That is how the court has considered. The application of the judgment in Uma Devi's by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the appellants were employed and have continued their service. The reliance on procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period through continuous service. Their promotion was based on a specific notification for vacancies and a subsequent circular, followed by a selection process involving written tests and interviews, which distinguishes their case from the appointments through backdoor entry, as discussed in case of Uma Devi. 7. The judgment in the case of Uma Devi also distinguished between irregular and illegal appointments, underscoring the importance of
Mr.
considering.
Mahanta, I'm sorry again to interrupt you.
Please.
You see, sometimes as a judge, I also realize that I have a tendency of going a little too fast. So you can block it when you want. But you see, there is a technical issue here.
Yes.
I'm putting it to you
Yes.
so that you get a chance to apply your mind and help the court to come at a conclusion.
Definitely.
There are two different circumstances.
Yes.
One is when the appointment is made irregularly, without sanction posts, without following the due procedure, ad hoc appointments, correct? These are bad appointments. But the judgments, here, there is no indication how these petitioners were initially appointed.
That is there, my lord.
How were they appointed?
They were appointed by through a process of selection. That is there. That is why
That is why I am saying your clients cannot get the benefit of this judgment. Their appointments are all valid.
we are also.
Yes,
We
they are there, your clients. They are contractual employees. They cannot
No,
switch.
we were appointed on contractual basis, but that was on the basis of advertisement, selection, the whole, following the entire process.
Please understand the question I am asking.
Please.
And I would really seek your expertise in this. But unless the expertise comes, an order is not possible.
Well, definitely.
See, the problem here is this.
Yes,
Contractual appointment is a different track.
yes.
It's a different legal relationship. Correct. And an
Exactly.
appointment on ad hoc basis without holding it, that is a completely different matter.
Different.
A contractual appointment is, in every sense, it is legal and valid,
Yes.
but it does not change its character from contractual to regular merely because time has been spent. I'm trying to put this to you.
My lord.
You please understand what I'm
Yes,
saying.
yes, yes, yes.
The contractual appointment follows a different track. Uma Devi has nothing to do with that. Nothing. And
Yes.
therefore, this judgment also has nothing to do with that.
No, Malab,
You can't argue that because I have been in contractual appointment for 20 years, now treat me as regular. That's not possible.
Malad, my respectful submission.
That's the difficulty.
Question is, when a person was duly selected, kindly see before that, let me go to my case, factual also. Lordship will find, how was it done first? How were we taken in? Here, there was an advertisement. It says, kindly see at page 38, Annex 1. They advertise those posts. Applications in standard type format are invited from eligible candidates of Indian origin to be engaged as accredited engineer, diploma holders on purely contractual basis under Mahatma Gandhi National Rural Employment Guarantee Scheme. Minimum qualification, so and so. Age was mentioned, this and that. Kindly come to next page. Engagement will be on contract basis and carry a fixed remuneration of rupees 10,000 per month. Applications along with all details including proof of age and qualification and 2 passport size photographs so and so. Prospect Director of DRDA district so and so against the desired engagement. The selection will be done at district level. Number of vacancies and detailed terms and are available with the respective project director DRD. No further correspondence in this regard will be entertained at Commissioner Panchayat and Rural Development Office. In overall requirement will be above 1,100 for the state. This was slightly modified again. And you see at page 40. Sorry, my lord.
You are unwell today. You want to do it?
Sorry.
You want to do it next week or something like that? If you're unwell?
My lord, I'm
No, that's all right.
Throat, that's right. I mean,
We can shift it a little, but I would request you to please consider this thought.
I get your lordship's point.
The court's sympathies are with your clients.
Right.
Don't have any doubt about it.
Yes.
But the court is confronted with a very, very technical area.
Right.
Where I'm saying this because some time back another matter was considered like this. See, here the problem is this. There is regularization means what? Absorbing someone against a regular post. Posts are created by the government. It's the prerogative of the government to create a post. Once the post is created, as you know, there are finance approval, etc., etc. The post carries various pension or no pension or medical or whatever. All these things are built into the post that is created.
Right.
Once a post is created, then Article 16 and 14 mandates that these posts are to be filled up in a particular manner.
Yeah.
Correct. So when there is a violation or aberration of that process, then sometimes no proper selection is held. Sometimes selection is held, but appointment is made without there being vacancies. All these things have been looked into in the case of Uma Devi and ML Kasari. Okay? Now, here the issue is little different. Your clients have been appointed and followed a process which is purely regular and valid. There can always be a contractual appointment. There's no difficulty. The terms and conditions of the appointment will be governed by the terms of the contract, which can be renewed. The contract will lay down what will be the salary, what will be the term, what will be. So it's a different track. What your clients are asking is to suddenly shift the track. And that argument is based on the fact that we have spent more than this many years in service. Logically, one would believe that why not? Where will these people go now? But for the court to issue a writ of mandamus, we will have to follow the principles of law.
Exactly.
Otherwise, the writ of mandamus will not lie.
Yes.
Correct?
Yes.
This judgment that you have relied upon, we appreciate. And obviously, if the ratio is binding, it has to be followed. But this is not a case of contractual appointment. The moment you told that they were contractual appointees, the first question that came to my mind is this. Contractual appointees, the only thing they can ask for, subject to what you may say, is that they can ask for age relaxation, preference, qualification norms, these, that, to participate in a regular selection. That they have been given. That has already been given.
No, we have
But
not
they
been
cannot
given-
seek a matter of right to be appointed or absorbed against a regular post. That at the moment
Court's view.
appears to be the law. And
Well,
if that is the law, then
My lord,
difficult
my
case.
lord, I wholly agree what your lordship has.
No, we would like you to disagree and convince us.
My lord, no, so for the
But-
other part is concerned, that one having been appointed by not in a legal.
Legal process.
So
There is
now,
a legal
in
process.
our case, we were recruited by following the legal process.
Yeah, but on contract
But on
basis.
contract basis.
Yes.
Now, lordship will appreciate that every appointment is a contract. First, every appointment, in whatever form, with the government is a contract. Now, we were taken in on contract basis, that you will be paid 10,000. These are your works. What did we do? We did perform, and we have been performing the duties of the junior engineers. That is the work we are entrusted to do, and we have been doing. Now, question would be again, we were recruited as accredited engineers. This is an ex-cadre post. This is an ex-cadre post. In the cadre, only junior engineers there. So what did I do? I did the jobs of the junior engineer. That is the only available in the department. This is the job. Ultimately, they have realized it that they have evolved, and because those posts were all lying vacant. Lots of you can kindly see those posts of junior engineers were not filled up. Those are all lying vacant. In the name of accredited engineers who have been employed, we have been working.
Those 344 posts, what has happened?
That is the issue, Lordship. Two
What is-
issues are involved.
Hmm.
One advertisement at page 66, Lordship.
Hmm.
It is advertisement dated 24 June 2020. Advertisement was for 344 number of posts of junior engineer, regular cadre, Lordship.
Hmm.
Lordship, initially a stay order was issued not to proceed with
Stay
the,
order in which case?
in this case, Lordship, not to proceed with recruitment. But subsequently, an IA was filed by the APSC, Lordship, for vacating the stay order.
Hmm. All right, you can just mention.
Lordship,
Yes.
therein, the honorable court was pleased to relax the stay order, barring 24 numbers of petitioners. Lordship, may kindly see one paragraph, Lordship.
So what has happened now? Out of the
Out
344?
of 344, 320 public select list has already been published. They were appointed.
Hmm.
But we are yet to publish the select list of the remaining 24 number of posts, Lordship. So that is one issue. But as my learned senior colleague has already submitted, in this petition, the only issue live is regularization of the petitioner's, Lordship. So in the IA, Lordship, if Lordship kindly see one paragraph, Lordship.
Hmm.
The ground taken, Lordship, these two notification, Lordship just now has seen that 14.8 and that age relaxation notification and the notification issued by the APSC were not to the knowledge of the petitioners. That was the only ground, Lordship. That is why the appointment to the remaining 24 posts were stayed. In my humble understanding,
They did
Lordship,
not participate in the selection process.
these 24 did not participate. In spite of giving the age relaxation more than 10 years.
No, that is not.
Lordship may kindly see.
Relaxation form.
Lordship may kindly see
There was
the
no
notification,
relaxation.
Lordship.
Could not participate.
Lordship may kindly see the notification at page 78. Just one paragraph, Lordship, one line. Notification dated 14th August 2020. Lordship may please come to page 79.
Yes.
Page 79, serial number 4, as is relaxation.
Hmm.
In addition to the above, the eligible contractual accredited engineers will be provided 10 years of age relaxation, or relaxation will be commensurate with the years of service put in the Panchayat and Rural Development Department as contractual accredited engineer, whichever is higher. So that much relaxation has been given. Next page, Lordship will see the notification. 17 August 2020, it was issued by the Public Service Commission. Roman ones, small Roman one. 10 years of age relaxation or relaxation will commensurate with the years of service put in the Panchayat and Rural Development Department as contractual accredited engineer, whichever is higher. So that relaxation was already there. In spite of that, they preferred not to participate in the recruitment. So today, Lordship, I am praying for a very small relief, Lordship. This restriction of not publishing the result of the remaining 24 persons, Lordship, that may be relaxed, Lordship. That may be relaxed, Lordship, because they are eligible candidates, Lordship. They have appeared in the examination. They are waiting for their results, Lordship. So that may be relaxed. So far as this petitioner is concerned, Lordship, another very important aspect is there. The petitioner number 1, he is Prabhat Kumar Kolita. He is saying that I am continuing in my service, but so far as my information is concerned, Lordship, his service has already been terminated in the year 2023. So that issue is not before your Lordship. So they are representing the petitioner. That issue at least be brought to the notice of this honorable court, Lordship. So today, Lordship, my only prayer will be, Lordship, the appointment to this 24 number of posts be relaxed, Lordship. It may be granted, Lordship. Other prayers have already become infractions, Lordship.
Lastly, the submission made that petition number 1.
So it was
has been
14,
terminated.
12, 2022.
No, all right, these are inconsequential. Whether he is the question is that do they have a right to seek a mandamus to be absorbed?
Yes.
If the answer is
What I
no,
want that
that
they
is-
should be conferred the status of regular employee. They should be treated as regular employees. That status should be conferred on them, and legally they are entitled to. This is my submission. We came here initially because though in that page 79 Lordship has seen, there was a clause that commensurating with the period of service they have rendered. That was not ultimately coming in aid of us. Therefore, the advertisement which was issued by APSC, they limited it to certain years, so we were excluded. Therefore, we approached this court stopped the request. That you cannot take these employees who are working like this without considering their case first. Ultimately, they came up with modification. Modification was granted in respect of those who have already appeared in the process of selection to go ahead with declaring their results, appointments, whatever they want. But in respect of only 28 who could not appear for want of their knowledge that they have not relaxed the age to include them also, court said that you keep this 28 posts vacant. 24 posts vacant. So these 24 posts are still lying vacant to be considered for these petitioners, 24 petitioners who are there entitled.
24 or 45 petitioners?
45 petitioners,
Were there
21
initially?
participated, 24 did not. That is why there is a stay of.
Out of these petitioners, some have participated,
Yes,
some.
21 participants. Lordship, may kindly have a.
Yes, yes,
It's a
but
very
some-
small paragraph, Lordship, paragraph 13, Lordship.
Those who
Last paragraph.
automatically walked in to the interview, they were taken in. Though there was no notification.
Mr. Mahanta, I'm sorry, you are a very senior counsel. You must be knowing your clients have missed the bus, as simple as that. They should have participated and got regularized. Who
Malad,
has given the legal advice? I don't know,
Malad,
but
Malad,
that's
no,
not our
no,
concern.
Malad, here kindly see, Malad.
That's not our concern.
Last paragraph, Lordship,
Question
paragraph 13. I'm sorry.
Kuntu
It's just IA too, sir.
That judgment, IA lordship and see. IA,
Yes.
IA to order to.
Lordship,
dismiss.
13. After hearing this is the vacating petition filed by the APSC, Lordship.
Mm.
After hearing the learned counsels for the parties, this court deems it proper and adjudication of the instant to miscellaneous applications to vacate the order dated 17/3/2022, thereby permitting the respondent authorities to go ahead with the selection process in view of the fact that 21 petitioners out of 45 petitioners had already participated and their cases were duly considered. It is a different thing that out of 21 petitioners who had participated, only one was selected. That is petitioner number 21, whose roll number was so and so. Under such circumstances, to stay the entire selection process for 344 posts at the behest of the petitioners herein would not be in the interest of justice. It is also relevant to mention that bare perusal of the executive order dated 14/8/2020, Lordship has just now seen that order, as well as the notification dated 17/8/2020, prima facie so that the persons who are contractual accredited engineers are and beyond 48 years would be considered. The respondents though submits that they have not insisted on the age limit and permitted all the contractual accredited engineers on to participate. However, it is prima facie view of the court that as on the face of the executive order dated 14/8/2020 and notification dated 17/8/2020, such relaxation being granted is not apparent. Lordship has perused that those two notifications, Lordship. This court, therefore, permits the respondent authorities to go ahead with the selection process. However, such selection shall be subject to the outcome of the writ petition. Further, taking into account of that 24 petitioners prima facie for want of knowledge that respondents have relaxed the age limit, did not participate, and taking into account that filling up of all the posts would lead to multiplicity of proceedings and creation of third-party rights. This court therefore directs respondents not to fill up 24 posts out of the 344 posts of junior engineer civil in the PNRE department until further orders. It is clarified that the 320 posts of the junior engineers can be filled up by the respondent authorities. So this fact of not to the knowledge of the petitioner's lordship. Lordship has just now seen that notification issued by the Public Service Commission, Lordship. It's a public notice.
Out of 45 petitioners, how many have participated?
21 participated, Lordship. Paragraph 13 itself. 21 participated, they were considered. And remaining 24 preferred not to participate. In spite of the public notice given.
Out of 21 participated, one got selected.
Yes, Lordship. One was selected, that is petitioner number 21. He was selected for appearing in the interview, Lordship.
Milord, if.
Yes.
So just that line. So Lordship, may kindly see page 80, Lordship. Page 80, it's a notification issued by the APSC, Lordship. It's a public notice.
Yes.
Public notice informing the eligible candidates. Serial number 1, Lordship, Roman 1. 10 years of, this is the age relaxation given to the petitioners. 10 years of his relaxation or relaxation will be commensurate with the years of service put in the Panchayat and Rural Development Departments as contractual accredited engineers. That is the petitioner's, Lordship. Lordship, they were given the relaxation. The numbers of these years.
They be entitled to the benefits of Upenda's
These are
regularization, they cannot.
contractual employees.
But will they be entitled to? This is the problem. I've been pointing it out.
Lordship.
Had their appointments been illegal, we could have granted them some relief.
Lordship, my humble understanding.
Your appointments are totally legal and it is in a beaten track. What you want is to sift the track now. That is the problem.
No,
If your clients were appointed irregularly or illegally, some relief was possible. Nothing illegal about your client's appointment.
My lord,
They chose to continue with this without being vigilant.
no, my lord, kindly look into from other angle.
That cannot be. That a read
Having
court
been
cannot.
appointed legally, but
Mr. Mohanto, that will create a havoc in the society. That you come in through contractual and then show a judgment and become regular employee.
no, no, my lord.
That you have to test it.
Lordship
in
will
the-
kindly allow me to
Hmm.
submit. A person who was initially taken in for contractual basis and was appointed as such, and he was used as a permanent employee to discharge all the duties of the permanent employee.
So he becomes a permanent
When,
employee.
when there are permanent posts lying vacant,
We'll consider your argument on that.
then lying vacant, and they have not taken a call that these people who were taken in contractual basis should be given either a regularization or they are to be discharged. Contract should be terminated. Now, how long they will continue like this? When there are particularly, my lord, kindly consider, when there are particularly permanent regular posts lying vacant, and we are discharging the duties of those particular posts, but at a cheaper wages. So, question is now for your lordship to consider. I will address your lordship on the next date on all these issues.
Next date means day after tomorrow.
Day after tomorrow?
Yes.
Yes, day after tomorrow. My lord, on that pretext, what right can be claimed by them? Whether their services have been evolved and accordingly, their rights have also evolved. If so, to what extent? That is beside it. If their rights have evolved to a better format, that right should be given to them. If not, then of course, they will have to continue for their whole life so long they are retained as the contractual employee. And after 14 years of service, 15 years of service, if they say, no, we are terminating. This will also go against the Article 14. Now, therefore, these issues, yes, prima facie, on the face of it, a person having been taken.
And another thing, you have 45 writ petitioners. Half of them are challenging the process, half of them have participated in the process.
My lord, they went helter-skelter.
But
What
was
to
the
do?
leave taken from the court?
No.
Did they participate with the leave of the court?
No, no.
Then?
Yes, Lordship. One order was there by this honorable court. In terms of that order, that relaxation order was, executive order was passed by the department. Lordship, may kindly see the order.
Another matter, Mr.
Same matter, same matter.
These petitioners, half of them have participated in this election process,
Lordship.
half of them have challenged it.
Yes, Lordship.
I am asking that. Was any leave taken by the?
Lordship, may
petitioner?
kindly see page 75. Page 75. One, another order.
Stuck up. You are talking about another court order.
Yes,
Yes.
I am asking about this
Lordship,
court order.
in terms of this order, relaxation was granted to the
I understand,
accredited
Mr.
institutions,
Nayak.
not in specific to the
I'm so
petitioner.
sorry, you are not even listening to what the court is saying. Sorry, Lord. This proceeding, they have challenged the earlier selection.
Yes.
Some of them have participated. How can they participate on the basis of leave granted by another order? It defies all logic. You are not even listening to the query.
I'm sorry.
No leave. My lord,
No leave, that's the ground to close the writ petition.
my lord, now, question
There
was,
is a conflict of interest.
those who have not participated, the cause remains alive for them. That is why I am before you. That is why.
Their case will have to be projected differently.
Lord, that is your
Can
lordship.
you argue equally for all the petitioners?
No, I am not arguing. That's why I said in the opening my mouth that I am only for 24. Only for those 24, while vacating the order, this honorable court said that now the case will survive only for 24. You don't fill up those 24 posts because for want of knowledge, for want of proper notification, they could not.
No,
Not that for want of knowledge, for want of proper notification.
How the case will survive for 24 and not for the other 20, whatever?
Since they have meanwhile
They are all petitioners.
True, my lord, true.
How can half of them take one course, half of them take another course?
My lord,
And the court will decide, what kind of a legal principle
my
supports
lord,
this?
apparently, it looks like that you have shifted, there are two groups.
It looks like no, it has happened.
My lord,
Your only option, Mr. Monta, you think about it. I have seen your papers. That's why I wanted to give you a little relief today from your, so that you can also look into it. This writ petition is no longer tenable. You can withdraw, and the 24 who have not participated, they may come and make a challenge. That is another matter. But even if they make a challenge, this is the hurdle which the petitioners will have to show. The petitioners who have participated,
yes,
they have done the right thing. But then they have participated and not succeeded. The matter ends there.
my lord,
And those who have not participated, they are asking for direct regularization. That if
my
they
lord,
still believe,
ultimately that claim is still pending by the association that was filed by their association for regularization. This writ petition is still pending before this honorable. This is by the association.
what
but
is
they
the
are
claim
not-
there? What is the claim in that writ petition?
Their regularization, that they are entitled to be regularized.
Then why do you need another one?
But that they are not pursuing it. Meanwhile, posts are being filled up. And we have even we were not allowed to participate in the process of selection also. Therefore, we had no option but to.
Who has stopped you?
Because the very notification says that after this age, you cannot. My age is more than.
You could have asked for further relaxation from the court.
Well, that relaxation, when the APSC has already said that this only possible. I said, how can you stop us? You cannot. Court said that you don't proceed.
All right.
That is the situation. That is the situation.
Most importantly, Lordship, the petitioner number 1, who has been authorized by the other petitioners to pursue this petition, himself participated in the interview, the recruitment. And in the meantime, Lordship, he has been terminated.
Oh, that is a very recent development, I'm told. He was.
Mr. Mahanta, anyway, the cases are not on perfect settings. We understand that. The court is conscious of your difficulties. But
I'm trying
there
my
is no
best.
scope for creating more mess. That's the only thing I will say.
Well, definitely. It would be always for the law courts. It would be always wanted.
There should be clarity what is happening.
Obviously, there should be a
Otherwise, it
very
doesn't
fair
serve
approach,
any purpose.
a direct approach, so that it can be. Now, I take your lordship's suggestion also. I'll definitely ponder it. But I know that my case is not that simple. But at the same time, it is not a case which can be thrown out on the face of it. That is my respectful submission as well as my understanding. Because law will evolve accordingly.
Let me give you a little bit of a response. Your clients may have a grievance, but whether they have a case or not is the only thing which will determine whether they get relief or not.
Exactly.
So merely because they have a grievance does not mean they have a good case.
True.
And if they have a good case does not mean they have a good grievance. There are two problems here. Please apply your mind with your experience, knowledge, vast knowledge. I'm sure there will be something in it for the petitioners.
I'm thankful.
There are two roadblocks you have.
Yes.
Number one is half of the petitioners have given up their primary challenge in the writ petition.
Yes.
They can't say that quash the selection process. In the meantime, let us see if we get selected, we'll get the job. So it is not permissible under the CPC for half of the petitioners or the plaintiffs to take one course, remaining half the another course. Even these 21 petitioners cannot withdraw from this writ petition. That's the law. I'm talking about the law. You know it. Should I mention the provision in the CPC?
No, I'm
you know. So, number one, on this ground, it is over. It's only a question of either it can be closed or there can be a withdrawal with liberty. But in that case, only thing you get is the remaining 24 can come. But the interim order will be vacated. it cannot continue. The second aspect is, even assuming that this 24 comes back afresh, you are asking for a writ of mandamus. The writ court can issue a writ of mandamus compelling the authorities to discharge their statutory or legal duty,
Yes.
not to implement what the judge feels
No,
individually.
never. Right?
You must show that they had a legal duty to
Exactly.
convert the contractual appointments
Yes.
into this, which you cannot show because the law cannot support such a thing.
Let me try.
That's the end of the matter.
Let me try on
Yes.
that form.
Had their appointments been irregular,
Yes.
illegal,
Yes.
you had a case.
Well,
But their appointments were perfectly legal. It is on a binding contract. There are two contractual entities. One hand it is state, other hand it is the individual. Sri Lekha Vidyarthi law is very well settled. Beyond that, the state has no further obligation except that it cannot act arbitrarily. So allowing a contractual appointee to continue in contract, is it arbitrary?
Well, it is, to that extent, the question is how long? How long?
As long
They
as
should
the
be-
contract
they should be
survives,
denied the
as
regular
long
bail.
as the contract survives,
That is the question.
that can't be helped.
That is
We
the
can't
question.
rewrite the law on this point.
That is the
If
question.
you are in a contract, you are governed by the terms of the contract, as simple as that.
True, Malak, that is
Yes.
true. That is true.
The contract
That-
has been renewed.
That.
How do you make an
that case-
exception
Yes.
and how do you change this law only for one case?
In that case, probably I will have some other relief. If I am continued on that, then I may have some other relief.
You may have.
Yes, I may have some
Examine
other
that.
relief. That I take it. But
Examine
is
that
my
and see
lordship
whether
point
the
out.
24 who have not participated,
Yes.
whether they should continue with this. Otherwise, I'm indicating it to you. It's hitting a roadblock. Not permissible.
Let me
Not
see.
permissible.
Let me.
And
point
then
out.
unnecessarily on a technical point, you get entangled. So please
No,
consider these
definitely.
angles
I'll definitely.
and
I'll
see.
definitely. Lordship may.
The court would ordinarily want people to be happy, people to get their dues. But then that has to be done in accordance
Yeah,
with law.
definitely.
We
I
have,
understand.
we have to administer
Court's
justice.
hands are also tied. They
Yes,
cannot-
we have to
even
do
if
justice in
desire-
accordance with
no,
law.
that
The
is-
posts require government implication, financial implication, burden on exchange.
Yes.
The judges cannot simply pass orders here and there.
Yeah, yes, no, never.
That these orders will be of no use. Anyways, I heard Mr.
Well, at the
Senior Counsel.
next.
Lordship has fixed this matter on 8, Lordship. Day after.
Day after tomorrow, not
Yes,
eight.
Lord. Lordship.
It's, 7.
6, 7, Lordship, yes.
Let it be next week, my lord. Let me, because those petitioners will have to take instruction from them.
Next week, these branches may not be available. Then it has to go beyond that. 19th.
19 possible, but Lordship will in that situation keep this matter as part of Lordship.
Yes.
Huh?
Part.
Oh.
No. These are all preliminary thoughts.
Yes.
The idea is to provoke a debate.
Definitely we'll try.
But
That's only.
we don't make up our mind till we write the judgment.
Even judgments has come, Lordship, but it has been held that contractual employment has no public element, Lordship.
Give the judgment. That's what I was saying.
I'll place the judgment.
I have said this a number of times. It is unfortunate that there is nothing wrong with your client's appointment. Unfortunate. Had there been something wrong, no post, irregular, no selection, things would have been. Sometimes this could be the nature of legal complication. There is nothing wrong. They were appointed, advertised, selected, they are in contract, continuing with their open eyes. Now they are saying, now switch us from this to that.
Yeah.
That's not possible.
Let us see. Let us.
19th?
Yes.
19th. Yes. Fixed parted matter. Yes. How many cases are there? Item 14, who is there?
Lordship, 14, I have just been informed Miss Yul Sharma, she was actually handling the brief, but she undergone a surgery, a gallbladder surgery. So may I pray the matter be taken after 3 weeks, Your Lordship?
You are making a submission on behalf of?
Yul Sharma, government advocate. Since the matter was parted, she was actually handling the brief. I just been handed over the brief.
You inform the petitioner's counsel.
He was just here, Your
No,
Lordship.
I am there. I have not been informed.
Now you are
Actually,
informed. What do you have to say?
A shorter date may fix, Lordship.
Shorter date, very short date, only 3 weeks. It is submitted at the bar that Mr. U. Sharma, learned government advocate Assam.
Miss Yul Sharma.
Miss U. Sharma, learned government advocate Assam, who is handling this brief, has undergone a medical surgery recently and is required to remain on rest. As such, a prayer has been made to adjourn the hearing of this case for 3 weeks. Mr.
J. Das.
J. Das, learned counsel, is present on behalf of the petitioner and does not oppose the said prayer. He, however, seeks posting of this matter as a fixed item after 3 weeks. In view of the above, register to list this matter as a fixed item after 3 weeks for hearing. What about item 16? Who is in item 16? 17?
My lords, I'm appearing in the item 17 to 26, my lords. We travel from Delhi, my lords, but today is on account of some personal exigency, we could not travel, my lords. I'm seeking a short adjournment, my lords.
You are appearing for whom?
I'm appearing for the respondent, my lords, internal cooperation, my lords. In all the matters, my lord, 17 to 26.
Okay, any objection?
My lord, I am appearing in 18. I have no objection. My lord.
I'm in 19. I have also no objection.
Achha, your name, please, Mr.
Avinash Agarwal, my lords. Avinash
So
Agarwal.
Avinash Agarwal, learned counsel representing the Indian Oil Corporation in this batch of writ petitions, submits that due to some personal difficulty, he could not come to Guwahati today to conduct the hearing of these writ petitions. As such, a request has been made to adjourn the hearing of these cases with a request to post the matters again after 3 weeks. The prayer is not opposed by learned counsel appearing for the writ petitioners in these petitions. Should be 3 weeks or 4 weeks?
My lords may keep
4
any
weeks,
date
4
fixed.
weeks. In view of the above, the prayer made by Mr. Agarwala stands allowed. Let these writ petitions be listed again after 4 weeks for hearing. Interim order is there?
No, my lord. In my case, no.
Then which remains? Item 16.
Deeply authorized.
Item 13. Who is there in item 13? Mr. Manan. He was here. No, at 2.
My lord, there is a matter which is going on legs in court 8, and I am there in item 13 in the opposite side.
You agree and take a time. Who is in item 14 then? 15, 16, sorry. Give them a date then.
Last week, November last week.
List this matter for final hearing on 20th of December.
Let it be 4 weeks.
Let it be 4 weeks, let it come. There are matters.
Manoj.
See, listing is not the end of the matter. It has to be taken up. So the order is to list it after 4 weeks as fixed item. Will you come? An interim order passed earlier to continue in item 17 to
20.
20. We'll have it extended, yes.
Item 13.
May I please your lordship? Lordship, before rising for lunch, we had apprised the court about the conducting counsel being on legs in court 8.
Has any request been made to you?
No, no requests have been made, but
Lordship, we informed.
just before your lordship rose, she told me that they made a request, that's it. Earlier, they did not have any.
So what do you have to say?
What can I say, your lordship?
I'll not keep it parted.
No, I'm not asking for part-head and all, your lordship, because this matter will take some time, because this is a departmental proceeding and this is the 5th round of litigation. Petitioner has already it was successful in the all the other rounds. Here, the issue is that he retired long back. And this is a matter, I think, 2016.
What was the penalty?
Penalty was reduction in the lower scale, no, in the same pay scale at the lower range of the same pay scale. But I have basically there are two options. One is with regard to the merit of the matter, and secondly on the technical ground, wherein there is a violation of the principle of natural justice. That part, these are the two parts. If I go for the merit part, you'll also have to go through basically the whole case. And this is the 5th litigation. So other earlier judgments are also there, which favored me in one sense or the other. So this is the reason. I cannot force my friend to actually argue, but this is the situation.
Yes, he did make a request.
Yes, I won't say lordship may then fix it, because the old matter, you can have it and fix it in another hearing day, your lordship, in that case. Because this will take a little time. That's also true. তোমার কোর্ট আছে
26th November,
লর্ডশিপ
26th November.
It's, yes. Social কিবা আছে লাইন 26 November, yes, lordship.
Mr. Y.S. Manan and counsel for the petitioner is present. When this matter was called up for hearing, a request has been made on behalf of the respondents seeking adjournment on the ground that the arguing counsel is unavailable today. Arguing counsel, Mr. S.P. Sharma, is not available to conduct the hearing of this case. Although this is very old matter and therefore calls for expeditious disposal, yet acting on the request of the respondents' counsel, hearing of this matter stands adjourned to 26/11/2024. List again on 26/11/2024 as a fixed item.
Lordship, if you would like to, lordship.
Item 16. Item 16.
You are appearing in this case, Mr. Dhar. None appears for the parties when this matter was called up for hearing. In view of the above, hearing of this case stands adjourned for 4 weeks. Yes.